Dear students, if you are asked to compare the power of Indian Supreme Court with its British counterpart, then what will be your answer? Can you say that the Indian Supreme Court is more powerful than the British Supreme Court? Now, a question has already been asked by UPSC from a similar topic in the main examination. Hello, I am Dr. Vivek Kaushik and I am a faculty of Optional Public Administration and Polity section of General Studies. Let me show you the question which UPSC has already asked from this topic. This is that system which, this question which UPSC has asked. Let's us read the question together. It says that judicial systems in India and UK seem to be converging as well as diverging. Highlight the key points of convergence and divergence between the two nations in terms of their judicial practices. Now, this question has been asked from a topic given in the syllabus of main examination called Comparison of Indian Constitution with that of other countries. Now, let me show you that topic in syllabus, that exact topic. This is that topic. So you can check the detailed syllabus of GS paper 2 main examination and you will find this topic in syllabus, comparison of the Indian constitutional scheme with that of other countries. Now, a similar topic we have in syllabus of our optional public administration. Let me show you that part of the syllabus. In optional, you all know we have two papers, paper 1, paper 2. So the paper 1 of public administration in its unit 7 mentions a similar topic in syllabus. Have a look. This is unit 7 of paper 1. It says comparative public administration, and I want to show you the topic number 2, administration and politics. Administration and politics in different countries. So from this topic also, last year, UPSC asked a question in optional public administration whereby it compared Indian system with that of French system. So the idea which I am trying to convey here is that this comparison of Indian political system, Indian constitution with that of other countries, it's a common topic for both optional public administration as well as general studies polity. Let us now discuss this topic and see that what are the differences between the two judicial systems. Now, differences between systems are many, but for the sake of to keep this video brief, I'm going to cover only a specific dimension, and that will be the power of judicial review. The power of judicial review. So if we compare this power of judicial review as it is available to British Supreme Court, and as it is available to the Indian Supreme Court, then what do we find? Now, before we compare the two Supreme Courts, we have to remember two key points. The first key point that we have to remember is that British political system is based on an unwritten constitution. Unwritten constitution. So it is an unwritten, or we can say it is an uncodified constitution. Whereas Indian constitution, we all know, it is a well-written, a detailed, a lengthy constitution. It is a written constitution. The second aspect that we have to remember before we compare the two Supreme Courts is that British political system is not based on supremacy of British Constitution. Rather, it is based on supremacy of Parliament. That means in Britain, not the Constitution is supreme, but the Parliament is the most supreme or sovereign body That is why we say that the British political system is based on Parliament's supremacy. In fact, it is said that the British Parliament is so powerful that it can do everything. It can do everything except changing a man into a woman and woman into a man, right? And that doctors can do. So except this, British Parliament is so powerful because British political system is based on Parliament's supremacy or Parliament's sovereignty. Whereas Indian political system is based on supremacy of Constitution. Supremacy of Constitution. So while we compare British Supreme Court with the Indian Supreme Court, these 2 points of differences we have to keep in our mind. Now, the first difference between two Supreme Courts is that Indian Supreme Court came into existence as soon as we got our Constitution, whereas British Supreme Court is quite recent in origin. It was established by Constitutional Reform Act 2005, and the Supreme Court, British Supreme Court, it started sitting only in 2009. So in terms of age, our Supreme Court is pretty old as compared to the British Supreme Court. The second difference is that Indian Supreme Court derives its power of judicial review from Article 32. Whereas, because Britain has unwritten constitution, so the British Supreme Court does not derive its power of judicial review from the written constitution because that does not exist, right? Third difference that we observe is that Indian Supreme Court can declare a law made by Parliament, an ordinance made by President, a policy made by Executive as null and void if it is found to be ultra vires, if it is found to be violative of the Constitution. It means our Supreme Court has the power of judicial review to declare even parliamentary laws as null and void. But because British political system is based on Parliament's sovereignty, Parliament's supremacy, therefore, British Supreme Court cannot overrule, cannot overturn, cannot set aside the laws made by Parliament. Understand it this way, that in Britain we have three organs. We have legislature, executive and judiciary. So judiciary, the British Supreme Court has power of judicial review, but that power of judicial review is very, very weak. Why is it weak? When the British Parliament makes any laws, let us call those laws as primary legislation. So any legislation or any law made by Parliament, British Parliament, can be called as primary legislation. Now, in this primary legislation, the legislature may delegate certain powers to executive. Delegate, you all know. I'm sure you have read in this topic in your polity classes that there is a concept called delegated legislation. That means when the legislature, it delegates some of its lawmaking powers to the executive, and exercising those powers, the executive will then make certain rules, regulations, orders, ordinances. So these are then called as delegated legislation. So let us say British Parliament makes a law which will be called primary legislation, in which it delegates some of its powers to the executive, and now the British executive, the government, it makes certain rules, it makes certain regulations, it makes certain orders, etc. Now these rules, regulations, orders will be called as secondary legislation. Secondary legislation. Now, because British political system is based on supremacy of legislature, so British Supreme Court cannot declare the legislation of Parliament as unconstitutional and thus null and void, but it can declare, British Supreme Court can declare the secondary legislation made by executive as what? As null and void if it is found to be ultra vires, if it is found to be violating the British Constitution or the law made by British Parliament. So now you can compare that the Indian Supreme Court can of course declare unconstitutional these secondary laws, but our Supreme Court can declare null and void even the laws made by Indian Parliament. But that cannot be done by British Supreme Court. Now, one more thing, remember that the British Supreme Court cannot declare primary laws as unconstitutional, but it can do one thing. And what is that? You all know that in Europe, there is a lot of emphasis on human rights. So there is a convention in Europe called as European Convention on Human Rights. And UK, Britain, is a signatory to this convention. It is a member, it has ratified this convention. So what Supreme Court can do? British Supreme Court. So the British Supreme Court cannot declare a law made by British Parliament as null and void, but it can declare that this law of Parliament is incompatible. It is not as per the provisions of European Convention on Human Rights. Now this declaration is called as Declaration of Incompatibility. It is called Declaration of Incompatibility. Incompatibility. This is what Supreme Court can do in Britain. However, once the British Supreme Court declares any parliamentary law as incompatible with this convention, then it is up to the Parliament, British Parliament, whether it would modify that law as per the convention or will it allow the same law to continue. But yes, this is what the British Supreme Court can do. So I hope now you understand some differences between the power of judicial review as it is available, as it exists in the Indian system versus how it exists, how it works in the British system. Now, there are some other dimensions of comparison between Indian judicial system and the British judicial system, which I will cover in some other video. I hope at least this concept is clear regarding this topic. We are going to start the next batch of optional public administration in Vajiram and Ravi in the month of April 2025. So if you are considering public administration as an optional, please contact Vajiram and Ravi for the new batch in April 2025. Thank you. Bye-bye.